Hello, I'm Bill Tingley. Every day, in courtrooms just like this, families seek help to solve their personal crises. Whether it's divorce, child abuse, or other family problems, the judges of family court try to decide the best course of action to help families work out their problems. We're going to take you inside family court to hear from the judges who make the decisions which change the lives of thousands of people in Jefferson County each year. Joining us on the show today is Judge Denise Clayton. Judge Clayton took the bench in 1996 and then volunteered to come and sit as a family court judge. Prior to taking the bench, she was the Associate Director of Legal Aid. Also with us today is Judge Patricia Walker FitzGerald. Judge FitzGerald took the family court bench in 1995. Prior to that, she was in the private practice of law, where she was a guardian ad litem for children. Judge FitzGerald, Judge Clayton, thank you for being our guest today. Our topic is domestic violence and emergency protective orders. Judge FitzGerald, start us out. Give us a good working definition of domestic violence.
All right. Domestic violence is an act or a series of acts that result in an assault or a physical injury or sexual abuse of a person. It can also involve an act that causes someone to think that they will be assaulted or injured or sexually abused. It is limited for our purposes to acts between family members. That can be a husband and a wife, it can be a parent and a child. It can also involve two people who have never been married and are not related by blood or marriage, but who have lived together or who have a child together.
So we're not talking about the partner that you're married with that maybe makes you emotionally crazy, are we? I mean, it's
No.
not emotional violence.
That's correct. It's not someone who just simply drives you crazy. It's not someone that you would like out of your life because you're tired of living with them or you find their habits annoying. It's someone who truly places you at risk of very real harm.
Judge,
Pardon me, I'd like
sure.
to add that it also involves couples of same-sex relationships if they live together in a relationship as if married.
I think that was fairly recently here within the last year or so, the Supreme Court clued us in on that.
That's correct.
All right. Judge Clayton, give us some things that you see, some instances that you see that aren't domestic violence, but some people have perhaps thought that it was.
Well, when you see petitions where people have brought things to court because they didn't get their car back, or they are really fighting over custody, and those things that are being alleged are not the things that Judge FitzGerald mentioned in the definition. So you'll get sometimes people really just trying to pay each other back for behavior that they don't like, or perhaps times where essentially the person did drive them crazy or cursed at them. A lot of people think that if they were cursed at, that that's enough to sustain a domestic violence petition, and that's not the case.
You mentioned the notion of perhaps being involved in a divorce and trying to get custody. It was a problem that we had with these orders when they first came down, wasn't it?
Right, and you still see it now sometimes with people really just doing this to set themselves up for the custody battle that's going to occur through the divorce action. So you have that happen.
What are have the judges developed any kind of policy regarding custody when they see this coming?
Well, you know, I think the first thing, of course, you always are going to do is to apply the statute. And if the statutory grounds are not met for the domestic violence, if there's been no acts of violence, if there have been no threats or intimidation or things that may create that fear that something's going to happen, then you have to, you know, overrule the petition. The domestic violence order can't be granted. So that's the first thing you have to do in all the cases, is to apply the law.
Judge FitzGerald, how many of these are you hearing on a regular basis? I know you just came off the bench here a few minutes ago and did, what, 25 today?
As an example, I had 23 today. We have 9 family court judges. Each of us has a docket where we hear domestic violence cases once a week. And I would say on an average week, I would hear 15 to 22 cases. That would be a very typical load. The numbers tend to be higher following a holiday. After Derby weekend, for example, the numbers are always a little bit higher.
Interesting. think I read a statistic that in the course of a year, you as family court judges will do somewhere around 5,200 EPO complaints to hearings. We're going to watch a videotape here in a minute that's going to show us what the actual process is, but could you give us, just before we play that, a little explanation? Let's start with you, Judge FitzGerald, on what the process is. So my spouse has pushed me against a wall. I'm afraid. What am I going to do?
You would go down to the courthouse to the clerk's office. The clerk would take the information from you and list it on a petition for a temporary emergency order. This would be an ex parte order, or an order that would be signed by a judge without a hearing. Okay,
now I'll back you up. When you say ex parte, I think it's important that we say that you're just going to hear one side of the story.
That's right. The clerk takes the piece of paper without the person who signed it and takes it to a judge. The judge will review the paper to see if on the face of the paper there are sufficient charges or allegations that there is an immediate harm. And there has to be, for the temporary order, a concern that the individual is in immediate danger of being harmed. If the judge finds that there is a danger, then a temporary restraining order will be entered, and that is good for only up to 14 days. A hearing has to be held within 14 days, and at that hearing both parties would be present and would have an opportunity to come forward and to tell the judge their sides of the story. Now, the judge may also find that there's not an immediate danger, but there are some concerns, and in that place there would be no restraining order entered, but the judge could say, you still both need to come to court to tell us what's going on to make sure that the parties will be safe.
Now, Judge Clayton, how important is it that these petitions or some form of action be taken by the victim at the first sign of trouble? Okay.
Let me first, if I may, back up to one thing to make sure people are clear about, and that is that they don't need an attorney to go and file that petition. I remember years ago there was a concern in terms of people doing this on their own and whether or not they could, but the whole idea here is for people to have 24-hour access to being able to take out an emergency protective order. But as to your question in terms of people taking out the orders, I have found that if people will take out the order or go forward to get an emergency protective order as soon as the first instance of violence happens within the relationship, I think there's a better likelihood that that violence can be stopped. And so I think people need to act immediately on that.
We talked in our preceding show about family court and one judge. Will the judge who signs the EPO or the emergency protective order, that initial 14-day order, will that necessarily be the same judge that hears the domestic violence case, that is, that actually hears the party's story?
No, it will not. In fact, a family court judge here in Jefferson County will be the one to hear the domestic violence case. The temporary order may be signed by one of the family court judges, or it may be signed by a district court judge who would normally sit in, say, traffic court or warrant court. It could be signed by one of the nighttime trial commissioners, since we are open 24 hours.
So someone who feels like they've been a victim of domestic violence can come in anytime, day or night, and get or apply for an EPO. Is that correct?
Absolutely. The law requires that no matter where you are in the state, each county must have 24-hour access to EPOs.
That's relatively new.
Yes.
Yes. Let's take a look at this video and on the process, and then we'll come back with some more questions.
An emergency protective order is a civil procedure for the problem of domestic violence. The purpose of the emergency protective order is to prevent domestic violence from occurring again by placing restrictions on the alleged abuser's actions. You begin by speaking with a circuit court clerk in the Hall of Justice. A victim of domestic violence can obtain an emergency protective order 24 hours a day. The person who files for an emergency protective order is called the petitioner. The person filed against, the alleged abuser, is called the respondent. If due to an emergency situation you cannot come to the Hall of Justice, another person may file for an emergency protective order for you. However, it must be notarized and supported by an affidavit from you, the petitioner, setting out the facts of the domestic violence. The law requires that in order to obtain an emergency protective order, a person must have been 1. Physically abused or assaulted, 2. Sexually abused or sexually assaulted, 3. Threatened with physical injury or assault, or 4. Placed in fear of imminent physical injury, sexual abuse, or sexual assault. Destruction of property alone is not grounds for an emergency protective order. However, the destruction of property along with the fear of injury may be sufficient. The parties must 1. Be married or formerly married, 2. Have a child in common, 3. Be closely related by blood or marriage, or 4. Formally or currently living together as a couple. An adult family member must file on behalf of any unmarried person under the age of 18. The clerk will ask specific questions regarding the acts of violence and abuse. The clerk will need the exact address or location where the alleged abuser lives or works. Date of birth and social security number of the alleged abuser are also useful pieces of information for the clerk. The clerk will ask you to describe the events that led to the filing of this petition. All the information will be placed on the petition. You can ask the judge to order your alleged abuser to 1. Have no contact with you, 2. Stay a certain distance away, 3. Not abuse or threaten you, 4. Refrain from damaging or destroying property, 5. Vacate the home shared by the parties. You may also request temporary custody of children. Your petition will be reviewed by a judge and a hearing will be scheduled within 14 days. You must attend this hearing. It is important to know the emergency protective order is not in effect until the alleged abuser is served or notified. This responsibility falls upon the Sheriff's Department. The Sheriff's Department serves the emergency protective order, explains the judge's orders, and advises the alleged abuser of the hearing date. If the alleged abuser violates any of the judge's orders, you should call the police. If the alleged abuser leaves before the police arrive, you should go back to the Hall of Justice to file for violation of the judge's orders. On the date of the hearing, emergency protective order cases are called one at a time into a courtroom. This is the opportunity for you to speak to the judge. It is important to remember that this may be the only hearing. You should bring any witnesses, photos, medical records, police reports, or other documentation which may be evidence of the abuse. A circuit court clerk may assist you in obtaining subpoenas for any witnesses. The judge's responsibility at the emergency protective order hearing is to listen to the facts of the case. If the judge determines that an act of domestic violence has occurred, then the judge will issue a domestic violence order. When children are involved, the court may enter orders of temporary custody and make provisions for visitation and child support. The court may also order one or both of the parties to receive education or counseling to help prevent future violence. Emergency protective order hearings are not designed for awarding maintenance or alimony or for dividing the parties' properties. There is also a family court support worker assigned to each division of family court to assist the judge and to coordinate services to the parties. With the filing of each emergency protective order, a copy is sent to the Department for Social Services. An adult protective services worker is assigned to contact you and offer protective and supportive services. If child abuse is alleged, A report will be made to Child Protective Services for investigation. Other resources are available to victims of domestic violence. The Center for Women and Family Spouse Abuse Center offers a comprehensive program of assistance. The Spouse Abuse Center provides shelter as well as court advocates who will attend court hearings at your request. The court recognizes that domestic violence is a serious social problem that takes an enormous toll both physically and emotionally on the people involved. The court will attempt to enter emergency protective orders when necessary and to hold offenders strictly accountable for their behavior. The court also recognizes that education is an important key to solving this problem. You are strongly encouraged to attend a domestic violence informational session before your court date. These sessions are free and may provide valuable information to you. The clerk can give you a schedule of the days, times, and locations of the sessions. Domestic violence is a serious problem that affects all aspects of society, all races, all religions, all social classes. And although it is difficult, the cycle of violence can be broken. Listen to the story of one woman who used an emergency protective order to escape a life of abuse.
For me, getting out of an abusive relationship took several small steps. The first was to file an emergency protective order, which gave me immediate protection against my abuser. This provided me with a safe environment for myself and my child, and no contact with that abusive person. Temporary custody was given to me for my child, which also gave me the opportunity to take time for myself to put my life back together. An emergency protective order does not solve all the problems and did not solve all the problems. However, it provided me with a safe environment, time to take for myself, and custody of my child. So for anyone who is filing, please continue to follow through with your emergency protective order and don't give up.